I'm looking at an article here published in 1986, and this is announcing the then government. They were announcing that a federal court judge is to hold a royal commission soon into the Chamberlain case. And this, of course, was when they opened up an inquiry into the convictions of Lindy Chamberlain and her husband Michael Chamberlain. It describes you here. You were the one appointed, and it says here you were regarded as the perfect choice for the job. That was a most important inquiry, the Azaria inquiry. And I'd just like to talk, you regarded it before, you said, as one of your main achievements in your life, and I'd like to talk to you a little bit about that case, if you will.
Well, I came into it only for the reason that the government approached our Chief Justice, as they always do, if they want a person to do an inquiry. I don't think they approached the judge direct. They said he didn't approach me direct. They approached Nigel Bowen and said, would you make one of your judges available? And he said, yes, I'll make Morling available. I was just asked to do it, and I regard it as being my duty to... You always, when you're on the bench, you take any case that comes unless there's some good reason, and there was no good reason why I could say to the Chief Justice, no, I won't do it.
Of course, though, it was a highly celebrated case. To this day, people talk about it.
Yes. It is extraordinary that if I go to Canada or England, people will raise it. It is. I suppose it's got a recipe for being extraordinary. You know, it was a young woman of blameless character, no suggestion of mental illness. A sort of a setting in the Wild West, so to speak, which is of itself unusual. Child never found. It's got a lot of angles to it, which made it a bit of a media storm thing, Right.
It may have been, of course, the big reason why you were appointed, because it says here, and this would have been the perception of you at the time, it says, it is because of his detachment, your detachment, that lawyers see him as so well suited to conduct the inquiry. So at that time, there was a need for a very strongly detached view because it was such a highly coloured case.
Yes. People had campaigned for and against it, the inquiry, I mean. I perhaps have been I don't think I've been too standoffish in getting involved once I was on the bench in any sort of social issue. Now, I think I might have been wrong about that, but I've taken the view, and I took the view then, that I would never speak to the press about anything, for instance. Even if I felt very strongly on some issue, I just would never answer the phone. I just simply sent a message back, thank you, but I think, I can't quite remember now, but there would have been a lot of lawyers taking sides, I think, in that matter.
I interviewed Ian Barker, QC. He will not discuss that case on public record. I also interviewed the late John Harper Phillips, who, unlike Ian Barker, had plenty to say, and he said, owing to his work in that case, and he was representing Lindy Chamberlain initially, it led to his passion for forensics and the desire to see justice done through a proper exploration of the forensic matters at hand. So, in a sense, it led to a crusade on his part for proper establishment of forensic exploration of things, and he played a very big role in the use of DNA testing, for example, and, criminal sites or homicidal sites and all that kind of thing. So I suppose it had different outcomes for different people. What was the lasting legacy from your point of view as a result of that inquiry?
Very much the same as Phillips. You always sort of have a you're affected by what you hear about issues before you start to hear a case. Before I spent a minute on that inquiry, I sort of subconsciously said to myself, well, look, this lady had a fair trial in front of Jim Muirhead, who was a very good, fair judge. She was convicted by a jury. She had a fair appeal. She lost that 3-0 in the federal court. She'd had another appeal to the High Court. She'd lost that. I said to myself, well, look, this is likely to be, of course it's now 7 or 8 years, or whatever, 5 years after the event. It's very unlikely I'll turn up any reasons for saying they all got it wrong, those people. So I started with a predisposition, sort of, well, this is just unlikely that she's going to get any mileage out of this. But it was the consistent reversal of the effect of scientific evidence upon which she must have been convicted by the jury that impacted on me, and I could see that it was so necessary, I think, to put caveats on scientific evidence against non-scientific evidence. I mean, when you think about it, and this is in effect what Bill Dean and Murphy said in the High Court, who dissented. They said, well, particularly Dean, who was a very good judge, and Murphy, this was one of Murphy's good decisions. They said the unlikelihood of her murdering the child was so overwhelming that you'd have to have a doubt. Well, I mean, that is so demonstrably true. She is a young woman. She's got 2 kids. She's delighted to have this third one. This is the evidence, uncontroverted evidence. Delighted to have this kid. So far from planning to get rid of her, she's putting things on lay-by, clothing for her, so, she's going to keep the child. She's got no mental illness. She had virtually no opportunity to murder the child. She had no opportunity to get rid of the child's body. That you'd have to say to yourself, well, this is mystery, but it's a mystery. You can't convict her. But what happened must have happened. I mean, she must have been convicted by the jury on the blood evidence. I mean, the Crown case is all supposition, but it had to be. She sits in the car with 8 people, twice the length of this room away. She's facing the people and she sits in the car. She uses a knife, which nobody ever found, cuts the baby's throat, blood spurts up under the panel, there's blood on the panel, it's baby's blood, and she's cross-examined Mr. Chamberlain, how do you explain your baby's blood being under there? She had to say, I can't. And it wasn't blood at all. I mean, that would, if you were a jury, you'd say to yourself, well, we don't know what happened, but if the baby's blood is under the car and she's sitting in that seat, it's got to be her. Wouldn't you think that? So that was just a dreadful,
John Harper Phillips felt very passionately about that it wasn't blood at all. It was a complete mistake on the part of the forensic pathologist who looked at it.